So happy. Everything worked today. We got online after the technical debacle of yesterday that was all triggered when I was prompted to change my password on Facebook, which I'm sure it's a good thing to do now and then. But the fact that it triggered all these other events was highly annoying. So I'm so glad we got back up and running today on time. Who's in the house as we light up the darkness? Stephen in New Hampshire, Bella in Florida, Renee in Indiana, Yehudit in South Carolina, Lorraine in Texas, Joe in the Inland Empire, Shandora in the Bronx, Belle in Texas as well. Change there. On the YouTube side, Frank in San Pedro, Elle in Southern California, Alan in New York City, Marjorie in Georgia, snowy Georgia. That can't be such a common occurrence. And Charles in Omaha, where probably snow is a little more common, right? I've never known it to snow in LA. I think it happened once in the last 100 years. But it was in the 30s this morning, which is pretty cold for us soft folk on the left coast. Karen in Northern California, welcome everybody. Our daf today is page 30 here in Tractate Sanhedrin, the 24th volume of the Talmud, continuing our journey through chapter 3. We've been discussing witnesses, who's qualified, who's not. In this Mishna number 5, we're talking about how judges examine the witnesses, questioning them, privately, one at a time, to make sure that they're getting the straight story. The Torah has already told us that a matter is established by the testimony of 2 or 3 witnesses, an interesting statement in the Torah. So if one, there are some exceptions, but generally if one witness testifies that they saw something, we haven't established the matter. We need 2 witnesses. There are some exceptions, but generally you need 2 witnesses. A question that will come up today is, do the 2 witnesses have to see it together and be aware of each other that they're seeing it at the same time? And do they have to testify at the same time before the court? Before we get to that, we'll finish up the discussion we opened yesterday, where 2 witnesses see somebody say, you know what, Reuven says, I owe Shimon money. I owe him 100 dinars. So somebody just heard him say that. They haven't heard anything. But if in the presence of two witnesses, and he says, I'm saying this in the presence of you and you, my witnesses, I owe Shimon 100 dinars, and Shimon is there too, then for sure Reuven is going to have to pay that 100 dinars. And then at the end of yesterday, we were talking about what if it's a deathbed confession and he calls witnesses, perhaps the one who is owed the money isn't there, but the witnesses are there and they can write it down, or they can say that they witnessed that he spoke this on his deathbed. If there are three witnesses there and he makes such an admission that he owes a certain amount of money, then they can write it down, because now three of them are not acting as witnesses, but they're actually acting as a court. It doesn't have to be rabbis who serve as judges. We've seen in certain cases, laymen can act as judges, and when there's three of them, so it's like they're setting down that before a court, he admitted that he owes this money and we wrote it down. And one of the things they're discussing is, do they have to make a kinyan to finalize that action? In other words, he says, I owe this money. And then it's like they transfer a handkerchief from one person to another to symbolically remove that money that he admits he owes to so-and-so. So they're taking it out of his possession and they're receiving it on behalf of so-and-so, or perhaps so-and-so is present there. And it was all either witnessed or the three were acting as a court, and then they wrote down the holding, the finding of the court that this man admitted before a court that he owes such and such, such and such amount to such and such person. That's where we were yesterday. Now, we're near the bottom of page 29b. So with regard to a certain document of admission, right? So could be a deathbed confession where there were three people present, and so they're saying that three are acting like a court, and they're going to make this document of what he admitted before them. That's what we mean by document of admission, in which the following statement was not written, that he, the one making the admission, said to us, write a deed and sign it and give it to the creditor. Right? So that's normally a formula that a court would write when somebody comes before them and says, yes, I owe such and such money, write it down in a deed and sign it. And what if that formula was missing from the text of this document of admission? Does that therefore disqualify the document? So Abaye and Rava both say that this is a case in which the principle of Reish Lakish is applicable. As Reish Lakish says, there is a presumption that witnesses do not sign on the document unless the deal was transacted with each party being an adult, even if it is not mentioned explicitly in the document that the witnesses verified this. Right? So a minor cannot enter into any kind of a contract. A person who's going to be a party to a contract and obligate himself to pay or to give or to render services, whatever, that person has to be an adult to enter into such an agreement. Does it need to say in the contract, let's say by the statement of the witnesses, that so-and-so who is an adult, and we verified that he's an adult, entered into this contract and we saw it? Answer, no, because the witnesses are signing their names on a contract. And if one of the parties wasn't an adult, they wouldn't have signed their names on that contract. So we can assume that certain terms, the fact that the contract exists at all, attest to the fact that these terms were met, like the fact that the parties to it were adults, and it doesn't have to be stated in the contract that the person was an adult. Likewise, the fact that he instructed, this assembled, this court of three to write down a document of admission, we understand that, well, they wouldn't have done that if he hadn't instructed them to do it, so he doesn't have to say the formula that he instructed us to do it. Now, Rav Papi objects to this, and some say it was Rav Huna, the son of Rav Yehoshua, who raises this objection. Is there anything that we, the sages, do not know, and the scribes of the court do know? Since not all the sages are aware that the witnesses of an admission cannot write a deed of admission unless the one making the admission asks them to, the scribes certainly cannot be expected to ensure that this condition is fulfilled. And the Gemara relates that Abaye's scribes were asked whether they were aware of this law, and they answered that they were aware of it. And Rava's scribes were also asked, and they were also aware of it. So apparently, since writing documents is their profession, scribes are aware of the relevant laws, even if not all of the sages are aware of these laws. Perhaps the sages know a lot, but they don't have to know, every bit about every body of law, every area of law, and they might not know this area of the law as well as the scribes who are, dealing with such documents every day. And the Gemara recounts, there was a certain document of admission, in which it was written that it was a record of the proceedings that took place in the presence of the witnesses, now on page 30a, and all of the formulations of an enactment of the court were written in it, but only 2 were signed on it. And the following statement was not written in it. We were convened in a session of 3 judges, and one of the judges is no longer here, as he died or left for another reason. So there was therefore room for concern that perhaps there were only 2 witnesses, and they wrote the document of admission improperly. In other words, were they supposed to be there as witnesses who could later testify that they heard somebody on his deathbed admit that he owed money to some person? Or were they there as a court because there were 3 of them, and therefore they could write down this document of admission? Since only 2 of them signed it, that might suggest that they were really supposed to be witnesses, not judges. And if they're witnesses, they shouldn't have written this document of admission. That was not part of their of their function in that situation. Only judges could write down a document of admission. And since only 2 of them signed it, what's going on? Well, it might end up that 2 of them signed it because, 3 of them heard it. And then, one of them sat down to write it. And by then, the third one had left town, went to the hospital, something happened to him. So even though there were 3 who properly heard the testimony, let's say this deathbed confession that the person who was about to die owed money to somebody, 3 of them heard it properly, therefore they could write the document of admission, but by the time they were ready to sign the document of admission as judges, one of the 3 was no longer available. It would still be a valid document of admission as long as there were 3 there when it was heard. So what's going to happen, right? So there was a certain document of admission in which it was written that it was a record of the proceedings and all the formulations of an enactment of the court were written on it. So it was written properly for a court document, but only 2 of them were signed on it. And the following statement was not written in it, that we were convened in a session of 3 judges and one of us had to leave before we made the document. So is this a proper document? And Ravina thought to say that this is a case in which the principle of Reish Lakish, that witnesses do not sign a document unless the action was performed properly, applies. So Rav Nassan Bar Ami said to him, this is what we say in the name of Rava. In any cases like this, we are concerned for the possibility of an erroneous court that thinks that 2 constitute a court. Maybe these 2 witnesses thought they could act as a court, even though there were only 2 of them. And so they heard the case as if they were a court and wrote up this document admission as if they were a court, but there never were 3 people there. And so we should be concerned because then it is an erroneous and improper document of admission. Rav Nachman Bar Yitzchak says, if it was written in the document, we, the members of the court, convened, then it is unnecessary for the deed to further state that one of the judges is no longer there, as a standard court consists of 3 judges, and presumably that's a very generally well-known law. Even if they were laymen, they would not have signed such a document if there were only 2 of them to act as the court. So the Gemara asks, but perhaps it was an impudent court. As Shmuel says, with regard to 2 judges who convened a tribunal and judged, their verdict is a binding verdict. But because they contravened, they contravened, right? They did not follow the rabbinic ordinance mandating that a court must be composed of 3 judges. They are called an impudent court. And the Gemara answers, it was a document in which it was written, we, the members of the court of Rabbana Ashi, convened. Rav Ashi's court presumably conformed to rabbinic protocol. So the Gemara asks, but perhaps the sages of the court of Rav Ashi hold, like Shmuel, that the verdict of 2 judges is binding. And in fact, they convened an impudent court. And the Gemara answers, it is a document in which it is written, and we said to Rabbana Ashi, and Rabbana Ashi said to us. Rav Ashi himself was there, and he certainly would not have participated in the discussions of an impudent court. There must have been 3 people there acting as judges. This was a proper document of admission, and we will follow it. New subject. Now, the Gemara returns to its discussion of when an admission is deemed credible. The sages taught in a baraisa in a case where one said to the children of another person, I saw that your father hid money in a chest, a box, or a cabinet, and he said, this money belongs to so-and-so, or this money is Meiser Sheni, second time. That when the temple was standing, it could only be used for the pilgrimage to Jerusalem during Passover or Shavuos or Sukkot. Therefore, it's consecrated money for that use. And then the money was found in that box, like this, friend of the father before he died said it would be found. So so the question is, somebody said, I saw that your father hid money in this box. And he's told me that the money that's in that box, he owes it to Reuven. And then the father dies. And so this guy tells that to his heirs. And the heirs go and they look in that box, and indeed there is money there. So since dad's friend told them truthfully that money would be found in that box, should he also be believed that that money is not theirs? It doesn't belong to the heirs, but rather it's owed to Reuven, and therefore they should pay it to Reuven. Now that this guy was credible in the sense that he said there's money in this box and the money was in that box, should we further believe him that it doesn't belong to the heirs, but rather it should be paid to so-and-so? Now, why should we take this guy's word for it? He's only a single witness. Maybe he has some ulterior motive. Maybe he saw that the father hid the money there, and then he made a deal with, Reuven. He says, listen, I'll tell the kids that the money's owed to you, and then I'll split it with you. Who knows? And so what is the answer? The answer is, we don't listen to him about who that money belongs to. He has said nothing. His testimony about the status of the money is not accepted because he is only one witness. And he could not have taken the money for himself had he wanted to, because the money was in this box or cabinet in the home of the father before he died, and where also the heirs live. But if it was in the field, then his statement stands, meaning it is accepted. Very interesting. If he says, well, your father hid money in this tree down in that field beside the stream, and then they go and dig up a hole under that tree, and indeed, there's a box there with a bunch of money in it. So there, since the father's friend could have just kept that money for himself and no one would have known, we believe him that the money really did, that the father buried it there, but it is owed to so-and-so. In this case, since the guy could have kept it for himself and he didn't, we're going to accept that that money actually does belong to Reuven. And the principle of the matter is as follows. In any case where it is in the power of the witness to take the money for himself, his statement stands. We believe him and he says that it's owed to so-and-so or it's been consecrated to such and such. But if it is not in his power to take the money, then he has said nothing, and we don't, in other words, like we're not going to remove the money from that sort of status quo of it's in the house and therefore in the estate of the deceased for the benefit of his heirs. We're not going to remove it from there if this guy didn't have the power to take it for himself, because he might have an ulterior motive to make such a statement now, and we're not going to accept this statement from the mouth of one witness. Now, in a case where the children themselves saw that their father hid money in a chest, a box, or a cabinet, and the father said, this money belongs to so-and-so, or this money is Meiser Sheni, second tithe. So if he said so as one who relays information to his own children, his statement stands. But if he said so as one who employs artifice, i.e., he appears to have told them that the money was not his, only so that they would not take it, then he has said nothing, and they may spend the money, right? So under what conditions did he tell them that this money in the box that they saw him put in the box belongs to so-and-so? Was he telling them, listen, this belongs to so-and-so, and after I die, make sure you give it to him? Or was he saying, this belongs to so-and-so, don't touch it? And maybe it doesn't belong to so-and-so, but they just the father wanted to make sure that these kids didn't take it for themselves. Reminiscent of a scene in that movie Sideways, which I saw not long ago, if you remember it, with Paul Giamatti. Let's keep going. In a case where one was distressed about money that his father left him as an inheritance because he could not find it. He knew his father left him money and then he can't find it. And the master of the dream came and said to him, it is such and such an amount of money and it is in such and such a place, but the money is Meiser Sheni. Who's the master of the dream? A character in his dream. There's a fascinating holding here. Right? So somebody knows that his father left him money and he can't find it. The father hid it very well, and now after the father dies, his son can't find the money. And then he has a dream, and a character in the dream, or even perhaps his father, comes to him in a dream and says to him, the money is in such and such a place. It's hidden under the dining room floor, near the wall. He goes and he digs, and there's the money. He never would have found it but for the information that he received in the dream. But the character in the dream also said, but the money's not yours. It has to be used for Meiser Sheni, or I owe it to Reuven. So then the question is, well, the dream, the character in the dream proved his worth by telling him where it is, and he wouldn't have found it otherwise. So does he also have to listen to the character in the dream to now pay that money to Reuven, or to only use it, to go up to Jerusalem for the festival, for second tithe? And what is the holding? And not only are we going to give a ruling on this, but this actually happened. This question came up before the sages. And this was an actual incident that was brought before the sages. And they said he can spend the money. The son who found the money, thanks to the character in the dream, can now go and spend the money. Why? Because matters appearing in dreams do not make a difference in determining practical halacha. Practical legal rulings in this world, we don't listen to dreams. So it's very nice that because of the dream, you were able to find the money. And perhaps, it's not so supernatural. Perhaps you actually saw, or your father told you and you couldn't remember, but your subconscious brought the information back to you in your dream, maybe. Or maybe it really came to you, from the other world, and your father wanted you to know where the money is. But dreams are also very topsy-turvy, and everything is always changing. So it's nice you were able to find the money, thanks to the information you got from the dream. But we're not also going to say that this statement made in the dream that you should give the money to so-and-so, that you're bound by that statement. You're not. Now, that's a legal matter. If you want to honor your father, and it was your father who came to you in the dream, and he said, this is where the money is, and you should give it to so-and-so, and you'd like to honor your father, wonderful. Probably a good thing to do. But you're not legally obligated to do that from information you heard in a dream. New subject. The Mishna teaches that if two judges say the defendant is exempt and one says he is liable, so he is exempt, right? You got a rabbinic court, there were 3 judges on the court. 2 say that you don't have to pay the money to the plaintiff, and the 3rd one says you do have to pay. Well, the ones who say you're exempt from paying outvoted the one who said you have to pay, so you're exempt, right? That's the ruling of the court, 2-1. So the Gemara asks, when there is a dispute between the judges, how do they write the verdict? So we get it. Because it was a 2-1 vote among the judges, in this case, 2 say exempt, 1 says liable, so the defendant is exempt. And he's going to have a written verdict from the court. How do they write the verdict? In other words, does the court simply say, we found you exempt? Does the court say, we found you exempt by a vote of 2-1? Or does the court say, we found you exempt by a vote of 2-1, and Judge Reuven and Judge Shimon said you're exempt, and Judge Levi said you're liable? Which of the 3 ways is that, right? Do we just give the verdict? Do we say that it was a split decision? Or do we say it was a split decision, and here's how the judges voted? Let's find out. Rabbi Yochanan says they write that he is exempt, period, without mentioning the fact that there was a split verdict. Reish Lakish says that they specify so-and-so and so-and-so deem him exempt, and so-and-so and so-and-so deem him liable. Right? So Reish Lakish would go to the 3rd option. We write that there was a split verdict, and we say which judge voted which way. Rabbi Eliezer says that they do not specify the names of the judges, but rather they add the phrase, from the statement of the judges, so-and-so, the litigant, was deemed exempt. They add this to the wording of the verdict, and this indicates that not all of the judges agreed that he is exempt, but we do not specify in the written verdict which judges came to which conclusion. Okay, so Rabbi Yochanan says we don't say anything, just the verdict. Reish Lakish says we give all the information, that it was a split verdict and which judge voted which way. And Rabbi Eliezer says we say it was a split verdict, but we don't identify which judge voted which way. The Gemara asks, what is the difference between these opinions besides the wording of the verdict? And the Gemara answers the practical difference between them is with regard to whether or not, in a case where it is discovered that the verdict of the judges was erroneous, that the judge who was in the minority must pay his portion of restitution along with the judges of the majority. Right? Now, this concerns the following situation. If you go to a beis din of ordained rabbis who are experts in the law, well, then you get a ruling from them, and even if they made a mistake, they don't have to pay. They did their best, and they're qualified to give such rulings. If you go to a court of laymen, and you're asking them to judge you, and they agree to judge you, and then they make a mistake, they are going to have to pay, right? They get the honor of acting as judges, but they have the responsibility that if they get the law wrong, they're going to have to make it good out of their own pocket. Or you can go to a court of laymen, but the litigants agree that even if there's an erroneous verdict, they accept the verdict, right? So those are the 3 possibilities. So if it was the situation of a court of laymen and the litigants didn't agree that they would accept even an erroneous verdict, well then if the judges get it wrong, then they have to make restitution. Now, if it was a 2-1 vote and they got it wrong, sounds like the one who was in the minority, he got it right. So why should he have to pay restitution? It should be the 2 who outvoted him and got it wrong. They should have to pay the restitution, right? Let's see. Okay, so what is the difference? The Gemara answers the practical difference between them is with regard to whether or not, in a case where it is discovered that the verdict was erroneous, the judge who was in the minority must pay his portion of the restitution along with the judges of the majority. As, according to the one who says that they write that he is exempt, the minority judge pays as well. And according to the one who says that they specify so, in other words, if the verdict was simply, the defendant is exempt, then the one who is in the minority, we don't know who he is, he's going to have to pay along with the three judges. They didn't even, because you don't even know that it was a split decision. If all they said was the court has held that the defendant is exempt, and then later it turns out that they got it wrong, well, this panel of three judges got it wrong, so they have to make the restitution. But according to the one who says that the court, in giving its verdict, this is Reish Lakish, would specify, that we came out with the defendant is not liable, and that was a result of two judges said he's not liable, and it was these two judges, and the third guy said no, he would be liable, but he was outvoted. So in that situation, the judge in the minority who got the law right but was overruled, he would not have to pay in the restitution later. The Gemara asks about that, but according to the one who says that they simply write he is exempt, right? They don't say that it was a split verdict or who voted. But if they just said that he's exempt, why does this judge in the minority have to pay? Let him say to the other judges, if you would have listened to me, you would not have to pay either. Why should I have to pay for your mistake? Rather, he doesn't pay in any case. And the practical difference between the opinions is with regard to whether or not those other judges must pay his portion of the restitution or not. According to the one who says that they write that the verdict is simply the defendant is exempt, so the judges who got it wrong, they pay the full sum, as they did not mention that there was a dispute over the matter. But according to the one who says that they specify that it was a split verdict and who voted each way, they do not pay the portion of the overruled judge, and he does not pay it either. He got it right. They mentioned that it was a split verdict, so now all they're going to have to pay is the 2/3, each 1/3 each of them, because they got it wrong. The Gemara asks, but according to the one who says that they simply write that the defendant is exempt, why do they pay his portion? I'm sorry, we had just read that. Oh, wait a minute. Oh, so the Gemara says, but it is not what I read before. But according to the one who says that all they write is that he is exempt, why do they pay his portion? Let them say to him, if you had not been with us, the judgment would have no verdict at all. Yeah, we overruled you, but if you hadn't been there, there would have been no verdict. Since you were there and you weren't able to talk us into it, well, then you're part of the court. Why should we pay your share? So rather, the difference between the opinions is only with regard to the wording of the verdict. And it is due to the prohibition of, you shall not go as a talebearer among your people, Leviticus 19:16. Right? This is what I said yesterday. If we know that it's not permitted for a judge to say to the litigants after the case, listen, I voted in your favor, but I was overruled. And that's not permitted, because that would violate the law, do not go as a talebearer. Then why would they ever reveal how they voted? Already we know you're not supposed to reveal to the litigants who voted which way. The litigants have to be satisfied that they got a verdict from this court. Reish Lakish says that they do specify who voted which way, and that it was a split verdict, because otherwise the document would have the appearance of falsehood. If they just said, this is the verdict, you might have thought that it was a unanimous verdict, because it says this is the verdict of the court. Now, you have no real reason to assume that, since we know that court could have a 2-1 verdict. Why should you assume that it was unanimous. You don't need to assume that. So that's why Reish Lakish lost this battle. And Rabbi Elazar accepts the opinion of this sage, Rabbi Yochanan, and he accepts the opinion of that sage, Reish Lakish. Therefore, this is what they write. From the statement of the judges, so-and-so was deemed exempt. And this wording indicates that it was a split verdict, but we're not going to tell you who voted which way. And that's the law. New topic. The Mishna teaches that after the judges finished the matter and reached a decision, they would bring them in. So the Gemara asks, whom would they bring in? If we say that they would bring in the litigants, well, this cannot be, as they were there the whole time. They never left the room. So does it mean that they bring in the witnesses? If so, in accordance with whose opinion is the Mishnah? It is not in accordance with the opinion of Rabbi Nassan, as it is taught in a Baraisa. The testimonies of individual witnesses are never combined into a testimony of two witnesses unless the two of them saw the incident transpire together as one. And Rabbi Yehoshua ben Korcha says their testimonies are combined, even in a case where they saw the incident one after the other. Right? So very interesting. What would that mean? What would that mean? Could it be that Reuven is going to owe money to Shimon. He's going to borrow money from Shimon, and he's going to do that in front of Dan. Right? So he does it in front of Dan. Now he knows he needs two witnesses, but there's only one witness there. There's Reuven and Shimon. Reuven is borrowing money from Shimon, and the only witness available is Dan. So Dan sees Reuven borrow the money from Shimon. And then Dan leaves because he's busy. But then Asher walks in. And so Reuven says, oh, wonderful. I'm borrowing money from Shimon, and we need a second witness. So you're seeing me borrow the money. I admit that I just borrowed money from Shimon. And Asher saw that. So both Dan and Asher witnessed that Reuven borrowed, let's say, $100 from Shimon. But they were not in the room at the same time. Presumably it's the same loan, but they were not in the room at the same time. So can we combine those two witness testimonies? That's what we're talking about here. Rabbi Yehoshua ben Korcha says, yeah, we could combine those. Even though they weren't in the room at the same time, we could combine them. And Rabbi Nassan says, no, they had to have seen it at the same time. They had to both be in the room when the loan was made, or the matter is not established and we have no witness testimony. Right? So Rabbi Korcha says they don't have to be in the room at the same time, but as long as it's about the same matter, we can combine their testimonies. Rabbi Nassan says we can't. So the Baraisa continues. And furthermore, their testimony does not stand in court unless the two of them testify together as one. So Dan and Asher according to this, not only needed to be both together when they saw the loan made, but they also have to come to court together. Rabbi Nassan says they need not testify together. Rather, their testimonies are combined. Even if the judges hear the statement of this witness today, and when the other witness comes tomorrow, the judges hear his statement. Right? So Dan could testify in front of the same court, these judges, on Monday, and Asher could testify on Tuesday. And as long as they're testifying about the same matter, we can combine those two witness testimonies. Now, the Gemara reverses its interpretation of the Mishnah. No, actually, it can be explained that the judges would bring in the litigants. Right? So when we said that after the judges deliberate, then they go bring them in. So the question is, who is them? So one idea was they bring in the witnesses, but maybe both witnesses aren't in court, according to what we just said. The witnesses, one of them might have testified on Monday, the other one testified on Tuesday. So it can't be that after the judges deliberate, they bring the witnesses back in. So it must be that they bring the litigants back in. When did the litigants leave the room? So the Gemara says, no, actually it can be explained that the judges would bring in the litigants. And this is in accordance with the opinion of Rabbi Nehemiah, as it is taught in a Baraisa that Rabbi Nehemiah says, this was the custom of the scrupulous people of Jerusalem. When they would judge, they would bring in the litigants and hear their statements, And then they would bring in the witnesses and hear their statements in the presence of the litigants. And then they would make them all go outside of the courtroom. And the judges would discuss the matter by themselves in the absence of both the litigants and the witnesses. And once the judges finished deliberating the case, then they would bring them, meaning the litigants, back into the courtroom to hear the verdict. So the Gemara asks, but isn't it taught in a baraisa explicitly? When they finished the matter, they would bring in the witnesses. It doesn't say that in our Mishnah, but in a baraisa it says explicitly, after deliberating, they would bring in the witnesses. So the Gemara answers, that baraisa is certainly not in accordance with the opinion of Rabbi Nassan, meaning if we're going to follow Rabbi Nassan, it seems like we are, at least at this point, and Rabbi Nassan is mentioned in the Mishnah, well, a baraisa, though contemporaneous with a Mishnah, is not as authoritative as a Mishnah. So, we often look at baraisas to get clarity on a matter, but if a Mishnah contradicts a baraisa, we follow the Mishnah. New topic. The Gemara discusses the matter itself. The testimonies about combining witness testimonies and combining witness, when they actually saw and what they saw. So the testimonies of individual witnesses are never combined into a testimony of two witnesses unless the two of them saw the incident transpire together as one, right? Dan and Asher both had to be in the room when Reuben borrowed money from Shimon. If they weren't both in the room together, then we cannot say that this is a pair of witnesses by whose testimony we can establish the matter. But Rabbi Yehoshua ben Korcha says their testimonies are combined, even in a case where they saw the incident one after the other. Like I said before, Dan saw Reuben borrow the money, and then he left. Then Asher came in, and Reuben said, look, I'm borrowing this money from Shimon. So Asher saw the same thing. So even though Dan and Asher weren't in the room at the same time, they both saw the same loan. And according to Rabbi Yehoshua ben Korcha, we could combine their testimonies into one valid pair of witnesses who saw it. And the Gemara asks, okay, so with regard to what do these two views disagree, that the two witnesses have to be in the room together or not? So the Gemara answers, if you wish, say that they disagree with regard to the interpretation of a verse in the Torah. And if you wish, say that they disagree with regard to logical reasoning. So the Gemara explains. If you wish, say that the two views, right, the unnamed view and the view of Rabbi Yehoshua ben Korcha, that they disagree with regard to logical reasoning. We're going to take the second case first. So the first Tana holds, the unattributed view, holds that the witnesses must see the incident transpire together, as otherwise, about the 100 dinars of debt that this one is testifying, that one is not testifying. And about the 100 dinars that one is testifying, this one is not testifying. There's only one witness of each incident, which is not sufficient. Because for all we know, when Dan was there in the first place, Reuben, and he saw Reuben borrow 100 dinars from Shimon, and then he left. And then Asher came in, and he saw Reuben borrow 100 dinars from Shimon. Well, maybe Reuben borrowed 200 dinars from Shimon. There were two 100 dinar loans that were separate loans, and each of them was witnessed by only one witness, which is to say there were no witnesses. If Reuben only borrowed 100 dinars once and the witnesses came one after the other, it would work, but how do we know that that's what the case was? Maybe there were two different loans. Since there was only one witness each time, we can't be sure. And that's what it is that we're worried about. And that's why we would demand that they both be in the room at the same time. Or at least the first Tana, that's what he demands. And the other Tana, Rabbi Yehoshua ben Korcha, holds that since both witnesses are testifying about 100 dinars in general, the defendant is liable to pay the plaintiff 100 dinars, right? Both of them saw that Reuben borrowed 100 dinars from Shimon. Maybe there were 2 loans for 100 dinars each. But at the very least, we know that Reuven borrowed 100 dinars, as both witnesses saw that, even though they weren't in the room at the same time. Therefore, Reuven does owe Shimon 100 dinars. Maybe he actually owes him 200. We can't establish that, but for sure we can establish that he owes 100. And if you wish, say that the first Tana and Rabbi Yehoshua ben Korcha disagree with regard to the interpretation of a verse in the Torah, as it is written in Leviticus 5:1. And if anyone sins, hearing the voice of adjuration, and he is a witness, whether he has seen or known, if he does not utter it, then he shall bear his iniquity. In other words, if there is a witness who, saw a matter that is now being litigated, and the witness doesn't step forward and offer his testimony when they're looking for a witness, then he is going to bear a sin because he should have spoken up and borne witness. Right? We don't want witnesses who avoid going to court when people have an obligation to establish a matter in court that's being litigated. Now, how does that prove that the two have to see it together or that they don't have to see it together? So the Gemara explains. And it is taught in a baraisa with regard to the verse, one witness shall not rise up against a man for any iniquity or for any sin, in any sin that he sins, at the mouth of 2 witnesses or at the mouth of 3 witnesses shall a matter be established. We can't establish a matter by the mouth of 1 witness. We need at least 2. And then the Torah also mentions 3, which is an interesting thing because once we know you need 2, what difference does it make if there's 3? But at any rate, 1 by itself is no good. That's Deuteronomy 19:15. So by inference, from that which is stated in the verse, that a witness shall not rise up against a man, even without the word one, do I not know that it is referring to 1 witness? After all, the verse is written in the singular. Therefore, what is the meaning when the verse states explicitly 1 witness? This established a paradigm, a basis for the principle that in every place in the Torah where the word witness is stated, it means that there are 2 witnesses, unless the verse specifies for you that it is referring to only 1 witness. If we're talking about witness, it's establishing a matter by witness testimony, it means that 2 witnesses are required. Since the Torah says that explicitly, even if it's written in the singular, we know it means 2, unless it explicitly says that something could be done by the testimony of a single witness. And according to the first Tana, who holds that the 2 witnesses have to be in the room together, the merciful one expresses it in the singular form, i.e. witness and not witnesses, to say that they are not combined into a testimony of 2 witnesses unless the 2 of them saw the incident transpire together as 1. They had to both be in the room. And the other Tana, Rabbi Yehoshua ben Korcha, derives from the phrase, and he is a witness, whether he has seen or known, right, that he has to step forward, that in any case where one testifies about what he sees and knows, his testimony is valid, right? He's just saying what he saw. So he's not going to lie because he was in the room with another witness or not. He's coming to tell the truth. If we can find 2 witnesses that saw the same thing, then even if they weren't in the same room at the same time, but they ended up seeing the same thing, effectively saw the same thing, then we should be able to combine their testimonies because they each came and spoke the truth. The baraisa cited above teaches, and furthermore, their testimony does not stand in court unless the 2 of them testify together as 1, right? So, there's a disagreement over whether they both had to see it at the same time. And now there's a disagreement about whether they both have to come into court on the same day to testify about what they saw. Rabbi Nassan says they need not testify together. Rather, their testimonies are combined. The judges hear the statements of this witness today, and when the other witness comes tomorrow, the judges hear his statement. And the Gemara asks, with regard to what do they disagree? And the Gemara answers, if you wish, say they disagree with regard to logical reasoning, and if you wish, say they disagree with regard to interpretation of a verse. So the Gemara explains, if you wish, say that they disagree with regard to logical reasoning. As one sage, the first Tana, holds that when one witness comes to testify, he comes to render the defendant liable to take an oath. This is the law when there is only one witness against the defendant in a case of monetary law. He does not come to render the defendant liable to pay money because for this, two witnesses are necessary. Right? So we saw this already, that in a case of capital law, right, one person comes and says, yeah, I saw this guy commit murder, or I saw this guy commit rape. There's only a single witness, the defendant will skate. But if it's a case of monetary law and a single witness comes and says, I saw Reuven lend $100 to Shimon. Now, there's not two witnesses, so we're not going to make Shimon pay the $100 to Reuven because there was only one witness. But the testimony of the single witness is enough that we would then say to Shimon, do you owe the money? And Shimon says, I don't owe the money. So then Shimon now has to take an oath. Right? If there were no witnesses, if it was only Reuven saying to Shimon, you owe me money, and Shimon says, I don't owe you money, and Reuven has no witnesses, Shimon can just leave. But if Reuven brings one witness and says, you owe me money, and he saw me lend it to you, and Shimon denies it, but there is one witness, Shimon can get out of paying the money, but he will have to swear an oath that he doesn't owe the money. And if he's not willing to swear an oath, he will have to pay. So the single witness in a monetary case makes the defendant have to take an oath in order to be exempt from payment. So what they're saying here is a single witness does have some power, right? It will lead to the defendant having to take an oath in order to be exempt. And the other Tana, Rabbi Nassan, responds, is that to say that when they come together, they render the defendant financially liable because they testify with one mouth? Obviously, they testify one after the other. Even if they come on the same day, they're not both speaking at the same time. We're going to hear the testimony of one witness, and then we're going to hear the testimony of the other witness. So what difference does it make if one testifies at 4 o'clock and one testifies at 5 o'clock, or if one testifies today at 4 o'clock and the other one testifies tomorrow at 9 a.m.? What difference does that make? It's still one after the other, according to Rabbi Nassan, so we should be able to accept that we have testimony of two witnesses, even if they're not in court on the same day. And if you wish, say, so that's by logical reasoning. And if you wish, say that what they disagree about is the interpretation of a verse. If he does not utter it, then he shall bear his iniquity, right? That somebody who knows is a witness and has testimony that will help one of the litigants, and he doesn't speak up, that he will bear his sin on account of avoiding giving testimony in court. Now we're on page 30b. And everyone, both the first Tana and Rabbi Nassan, holds in accordance with the opinion of the rabbis who disagree with Rabbi Yehoshua ben Korcha, and derive from this verse that it is necessary that the witnesses see the incident together, i.e., they were both present and they observed the incident at the same time. And here, with regard to whether or not the witnesses must testify in court together, they disagree with regard to whether or not the statement of the witnesses, i.e., their testimony in court, is compared to their observation of the incident. So one sage, the first Tana, holds that we compare the statement to the observation. Therefore, just as they must see the incident together, so too they must testify together. And the other sage, Rabbi Nassan, holds that we do not compare the statement to the observation. Rabbi Nassan says they both have to see it together, but they don't have to state what they saw on the same day. And the Gemara relates that Rabbi Shimon ben Eliakim was striving to ordain Rabbi Yosei, the son of Rabbi Hanina, and he was not successful in his attempt. Right? Rabbi Shimon ben Eliakim was trying to get the other sages to agree to ordain Rabbi Yosei, the son of Rabbi Hanina, and they weren't agreeing. or he was just simply not able to convene the court necessary for ordination. Stuff kept coming up. One day, Rabbi Shimon ben Eliakim was sitting before Rabbi Yochanan among Rabbi Yochanan's other students. And Rabbi Yochanan said to his students, "Is there anyone who knows whether the law is in accordance with the opinion of Rabbi Yehoshua ben Korcha, that they don't have to see it together? Is that the law or not?" And Rabbi Shimon ben Eliakim, who was trying to get Rabbi Yosei ordained, so Rabbi Shimon ben Eliakim said to Rabbi Yochanan, "Well, this one, Rabbi Yosei, the son of Rabbi Hanina, he knows the answer to your question." So Rabbi Yochanan said to him, "Well, if so, let him say the answer." And Rabbi Shimon ben Eliakim said to him, "Let the master ordain him first. Since we are all in need of his wisdom, he is fit for ordination." So Rabbi Yochanan then ordained Rabbi Yosei, the son of Rabbi Hanina. Rabbi Yochanan said to him, "My son, tell me what you heard." And Rabbi Yosei, the son of Rabbi Hanina, said to him, "This is what I heard, that Rabbi Yehoshua ben Korcha concedes to the opinion of Rabbi Nassan that it is unnecessary for the witnesses to testify together." Was that the question? Is it whether they need to testify together, or is it that they need to observe it together? Rabbi Yochanan was disappointed and said, "For this I needed to ordain him. Now that with regard to the main element of testimony, i.e. observing the incident, Rabbi Yehoshua ben Korcha says we do not need both witnesses to see it together. So then with regard to their statement in court, is it necessary to explicate that there is no requirement that they testify together?" I mean, obviously, if Rabbi Yehoshua ben Korcha says they don't have to be in the same room together when it happened, why would he say that they both have to be in court when they're going to give their testimony on the same day? Why would it have to be on the same day? Although this statement of Rabbi Yosef, the son of Rabbi Hanina, was unnecessary, Rabbi Yochanan said to him, "Well, since you ascended," meaning since I've ordained you, "you will not descend, even though I should not have ordained you. Now that you're ordained, you stay ordained." And Rabbi Zera said, "Conclude from it that with regard to a great man, once he is ordained, even if it was due to mistaken judgment, he is ordained. The ordination is not canceled." And recall that when we're talking about ordination in the Gemara, it's not like, today where, you go to rabbinical school or you have sufficient learning from some rabbi and he ordains you, and then, you join the legions of rabbis in the world. There are many, many, many rabbis in the world. Back then, when you talk about ordination, it meant elevated to the level of a sage. As for the law in this matter, Rabbi Chia bar Avin says that Rav says the law, the halacha, is in accordance with the opinion of Rabbi Yehoshua ben Korcha, that it is unnecessary for the two witnesses to observe the incident together, both with regard to cases of land and with regard to cases of movable property. That's the law. Ula says the law is in accordance with the opinion of Rabbi Yehoshua ben Korcha with regard to land, which is unmovable, and therefore both testimonies are certainly about the same piece of land, but not with regard to movable property, as there is a concern that they are not testifying about the same item. They weren't in the room at the same time. Maybe they saw that Reuven, agreed that he owes, what's a fungible item that's not money? I don't know, a chair. He says, "Yeah, I owe you a chair, and so Shimon, this chair is yours." And Dan saw that, and then Dan left, and then Asher came in, and he heard Reuven say to Shimon, "Yeah, I owe you this chair." Now, how do we know they're talking about the same chair? Maybe Reuven owes Shimon 2 chairs, but Dan only saw him admit that he owes one of the chairs, and Asher only saw him admit that he owes the other chair, and so neither one of the chairs that Reuven admitted owing, was witnessed by 2 witnesses. So we haven't established anything, and Reuven shouldn't have to pay any chairs. That's what Ula's concern is. Abaye said to Ula, "If you say that the law is in accordance with the opinion of Rabbi Yehoshua ben Korcha with regard to land, by inference, you hold that they disagree with regard to this matter. But doesn't Rabbi Abba say that Rav Huna says that Rav says? The rabbis concede to the opinion of Rabbi Yehoshua ben Korcha with regard to testimony concerning land. Everyone agrees that the witnesses don't have to be there at the same time in a matter that involves land. And Rav Idi bar Avin teaches in the laws of damages that were taught at the school of the sage Karna, that the rabbis concede to the opinion of Rabbi Yehoshua ben Korcha that the witnesses do not need to see the incident together with regard to testimony concerning a blemish in a male firstborn kosher animal, right? A bechor, if the first offspring that comes out of the womb of a cow, right? Her first calf is a male, so we're not allowed to eat that calf, that male calf. It needs to be sacrificed as a bechor, as the first offspring to emerge from the womb of that cow. But if it develops a blemish so that it cannot be brought as a sacrifice, and we don't follow this now, when the temple is not standing, but when the temple was standing, the bechor had to be brought as a sacrifice. But if it developed a blemish, then it can't be brought as a sacrifice, and then people can eat it. As opposed to an animal that is consecrated to be brought, for example, as a sin offering, then if it develops a blemish, it cannot be brought as an offering, but neither can it be eaten because it's already been consecrated. A bechor is not at that same level of consecration. So if it develops a blemish, it can be eaten. So the rabbis concede to Rabbi Yehoshua ben Korcha that if two people saw that this animal had developed a blemish, then it is permitted for eating, even if the two people were not in the room together. Since it is clear that they are testifying about the same, and also with regard to land, with regard to testimony concerning presumptive ownership of the land, right? As we talked about yesterday, that different pairs of witnesses saw that a person was farming this field for 3 consecutive years. None of the pairs of witnesses saw him all 3 years, but there were 3 separate pairs of witnesses who could testify that he was there in year 1, year 2, and year 3, and we could combine those testimonies and give him the chazaka of ownership. And so they weren't all there at the same time, but it works. So therefore, the rabbis concede to Rabbi Yehoshua ben Korcha with respect to land and with respect to this bechor that develops a blemish. And they also concede to Rabbi Yehoshua ben Korcha with regard to testimony over the 2 hairs of a boy or of a girl, which are a sign of adulthood. Right? So when a boy or girl reaches a certain age, they still might not be considered an adult if they haven't developed signs of puberty. And these hairs would be signs of puberty. And the Gemara rejects Abaye's question. So the 2 witnesses don't have to see the hairs at the same time. Are you setting the statement of one man against the statement of another man? One sage, Ula, holds that the rabbis disagree with Rabbi Yehoshua ben Korcha, even with regard to land. And the other sage, meaning Rav and Rav Idi, they hold that the sages do not disagree. The rabbis do not disagree with, they concede to Rabbi Yehoshua ben Korcha. So we have 2 different views on what that dispute was in an earlier generation. So the Gemara asks tangentially about the statement, and so they concede with regard to testimony over the hairs of a boy or of a girl. What is this referring to? If we say it is referring to testimony that a girl has reached adulthood, in which one witness says that he saw 1 hair on her lower back, and the other witness says that he saw 1 hair on her lower abdomen, well, this is difficult. A girl is considered to have reached maturity when she has 2 hairs. In this case, 2 witnesses separately testify that they have each seen 1 hair. So in this case, each testimony by itself is obviously invalid, as it is half a matter and also half a testimony. Only 1 witness at a time, and what they saw did not establish the matter because they only saw 1 hair, not 2 hairs. So we have both. It's only 1 person, not 2, and what they saw would not establish the girl as an adult because they only saw 1 of the 2 hairs. So not only does each testimony refer to only one hair, which is half a matter, but it is submitted by only one witness, which is half a testimony. So consequently, it is obvious that the girl is not considered to have reached adulthood according to this testimony. So rather, it must be referring to a case where one witness says that he saw 2 hairs on the girl, on her back, and the other witness says he saw 2 hairs and it was on her lower abdomen. Since they each testified that she has reached adulthood, it is unnecessary for them to see the same hairs. Each of them saw 2 hairs on the same person. Even though they saw it separately, now we could combine the testimonies, at least according to Rabbi Yehoshua ben Korcha. So Rav Yosef said, I say in the name of Ula that the law is in accordance with the opinion of Rabbi Yehoshua ben Korcha, both with regard to land and with regard to movable property. But the sages who came from Mechoza say that Rabbi Zera says in the name of Rav, with regard to land, the law is in accordance with the opinion of Rabbi Yehoshua ben Korcha, but not with regard to movable property, where the 2 witnesses might be testifying about different objects that were the subject of the litigation. So the Gemara comments, Rav conforms to a standard line of reasoning, as Rav says, testimonies of an admission following an admission are combined into one. If one witness testifies that the respondent admitted in his presence that he owes the claimant, and the other witness testifies that the respondent admitted in his presence that he owes the claimant in a separate incident, their testimonies are combined. And likewise, testimonies of an admission following a loan are combined into one, where one witness testifies that the respondent admitted in his presence that he owes the money, and the other witness testifies that on a previous date, the respondent borrowed money from the claimant in his presence, right? When Dan was in the room, he saw Shimon lend money to Reuven, and then he left. And then Asher came in the room, and Reuven said, I just borrowed money from Shimon, right? So one of them saw the loan happen, and the other one saw that, the borrower admitted that he just borrowed money from the lender in front of this witness. So one witness saw the loan, the other witness saw the admission, but it was referring to the same loan, so we can combine those 2 testimonies to be a pair of witnesses to establish the matter if it's being litigated later. Rav continues, but testimonies of a loan following a loan, these are not combined. If one testifies that the claimant lent the respondent 100 dinars in his presence, and the other witness testifies that he lent them 100 dinars in a separate incident in his presence, their testimonies are not combined, as they are clearly testifying about 2 separate loans. Dan says, I saw Reuven lend Shimon 100 dinars on Monday. Asher says, I saw Reuven lend Shimon 100 dinars on Tuesday. Those are obviously separate incidents. So probably there were 2 loans, but each loan was only in front of one witness. So this testimony has not established anything. And similarly, testimonies of a loan following an admission are not combined. If one testifies that the claimant lent money to the respondent, and the other one testifies that on an earlier date, the respondent admitted to owing the claimant, these testimonies are not combined because they're clearly referring to separate incidents. Rav Nachman bar Yitzchak encountered Rav Huna, the son of Rav Yehoshua, and he said to him, what is different about a loan following a loan, in which case the testimonies are not combined, as the 100 dinars that this witness saw, that witness didn't see? In the case of an admission following an admission as well, perhaps the 100 dinars about which the respondent admitted in the presence of this witness, he did not admit in the presence of that witness. Perhaps his admissions were in reference to 2 separate loans, and therefore the testimonies should not be combined. Why would we combine them? And Rav Huna, the son of Rav Yehoshua, answered him, the reference is to a case where the respondent said to this last witness, with regard to the 100 dinars that I admitted to owing in your presence, I admitted to owing them in the presence of so-and-so, the first witness as well, right? When Asher comes into the room and Reuven says, I want you to know that I borrowed money from Shimon, and I'm telling you that. And when I borrowed the money from Shimon, I did so in the presence of Dan, who was here earlier. Or I'm admitting to you now that I owe money to Shimon, and earlier I made the same admission in front of Dan. So Asher knows that the admission that he just heard was also uttered in the presence of another witness. Asher knows that there are 2 witnesses and he's one of them. And Rav Nachman Bar Yitzchak asked, but still, the last witness knows that he is testifying about the same loan as the first witness, but the first witness does not know this. Since only one witness testifies that it is the same loan, the testimony still should not be combined. So Rav Huna, the son of Rav Yehoshua, said, and I'm almost done, questions or comments, please get them in now. So Rav Huna, the son of Rav Yehoshua, answered, it is a case where, after his admission to the second witness, the respondent went back, found the first witness, and said to him, with regard to those 100 dinars that I admitted to owing in your presence, I admitted owing them in the presence of so-and-so as well. Therefore, both witnesses know that they are testifying about the same loan and that it was admitted in front of two people, and they know who the two people are, each one. Therefore, both witnesses know that they are testifying about the same loan. Rav Nachman Bar Yitzchak said to him, may your mind be settled as you have settled my mind, and put it at ease by answering this question that was troubling me. Rav Huna, the son of Rav Yehoshua, said to him, what is settling about this explanation? As Rava, and some say Rav Sheshis, threw an axe at my master, i.e. he rejected my explanation, as follows. According to this interpretation of the case of an admission following an admission, isn't this the same as an admission following a loan? The case of an admission following an admission is now rendered superfluous, as it adds no new insight in the matter. Once we know that you can take combined testimonies of an admission following a loan, an admission following an admission is the same principle. Rav Nachman Bar Yitzchak said to him, this is what I heard about you sages of Mechoza, that you knock down palm trees and erect them, i.e. you build and then destroy what you built. After you came up with such an excellent explanation, you ruined it yourselves. And the sages of Nehardea say, whether it is a case of an admission following an admission, or an admission following a loan following a loan, or a loan following an admission, in all these cases, the testimonies are combined. In accordance with whose opinion is this? It is in accordance with the opinion of Rabbi Yehoshua ben Korcha, who teaches that since both witnesses testify about a debt of 100 dinars, it is considered like one testimony, because at the very least, even if there were two loans, we can say that at the very least he owes the 100 dinars, and we can combine the two witness testimonies for that, even though they weren't in the same room at the same time, and even though they don't testify in the same day in court, we can combine those two witness testimonies to create one valid pair of witnesses. Okay. Renee, my dad of blessed memory comes to my dreams to go water skiing. Weird and reminiscent of my youth. If only he came with treasure. LOL. Thank you, Renee. Sharon, I had a strange sense that my dad would be passing soon when he told me that he was dreaming about his mother, who died in Poland when he was 12 years old. And he not only saw her, but actually heard her voice. Wow. Thank you. Sharon also says, I would think the witnesses should not be permitted to testify at the same time, if for no other reason to ascertain, validate one another without influencing one another. No, you got that right. All we're saying is that they have to testify on the same day. But we learned earlier that they do not testify in each other's presence for exactly the same reason that you're saying, Sharon, because we don't want them to sort of coach each other and just learn from what the other one said to say exactly the same thing. No, they have to be examined separately. The question is, can they be examined on separate days? Then the later question was, if it's the same three judges, but we have a circuit court, like Abraham Lincoln, when he was a circuit lawyer, what that meant was not every town had a courthouse, but the lawyers and the judge or judges, they would ride the circuit. And so they would be in a small town on Monday, and then another small town on Tuesday, and another small town on Wednesday, right? And the court would move from town to town. Well, maybe there was a witness. Maybe you need two pairs of witnesses. You need two witnesses. And one witness was available on Monday. And the other witness was not available on Tuesday. Was not available on Monday, but he was available on Tuesday. But on Tuesday, the court has moved. So can we say that they're a valid pair of witnesses if they're testifying about the same matter, but one of them testifies on Monday, the other one testifies on Tuesday, and they actually testify in different locations? Can we combine those testimonies? Certainly we can combine them if the court doesn't change locations, and I believe they could also combine them even if the court changes locations. Then another question would be, what if it's a different set of judges? Can we combine two testimonies that are given before different groups of judges? That's much more problematic. Renee, if a guy is willing to bear the iniquity of denying a debt that he owes, it seems that it would not be much of a deterrent for him to swear a false oath. Lenders need witnesses, belt and suspenders. I think yes and no. I think that if a person, especially in a pious community, says, I don't remember lending you money, I don't want to pay. And the other guy says, I'm sure, and here's my witness that you did lend it to me. So you don't have to pay me because I only have one witness, but are you willing to swear an oath? And the guy's like, well, okay, I'll pay. So I think that there is a difference between, especially because when you swear an oath in court, they're going to adjure you that the thing that you're about to do, to swear an oath before God, is a very serious matter, and you'll pay a price in this world and the next if you are swearing falsely. And since a person, might not remember very well, and he's not sure, so because he's not sure, he doesn't want to pay. But because he's not sure, he also doesn't want to swear a false oath. So that's where I think the oath can be quite effective. That's what I've got for us today. And with God's help, we'll be together again tomorrow, Wednesday, regular Wednesday time, 6 p.m. Pacific. Have a great night.